Okay, good morning, everyone. Thank you so much. I'm sorry, good afternoon. Thank you so much for joining us this afternoon for the free legal webinar. Bill will be talking about demystifying contracts. I want to remind you, if you have any questions, please utilize the chat box you can find on the bottom of your desktop there. And today we also have the option of a language interpretation.
Perfecto, muy buenas tardes a todos. Reina Rodríguez para servirles. El día de hoy estaré ayudando con interpretación simultánea. Eso quiere decir que la interpretación será en tiempo real. Si usted gusta accesar la interpretación, en un momento usted va a ver en su pantalla un icono que parece un globito, un mundo. Usted va a seleccionar el icono y después va a seleccionar su lenguaje de preferencia. En este caso sería el español. Le invito a poner el audio original en silencio para que de esta manera no escuche ningún eco del audio de inglés. Y si usted tiene cualquier pregunta o comentario que le gustaría hacer, le invitamos a que de igual manera usted puede someter su comentario por medio de la función del chat que está abajo de la pantalla, al pie de la función de participantes. Bienvenidos.
Thank you so much, Reina. So this is today's agenda. Now, I would briefly like to share about the Fresno Area Hispanic Foundation. We are a nonprofit who offer assistance to small business owners as well as entrepreneurs who would like to begin their business. We offer technical assistance. That's one-on-one assistance with any problem you may have. We also refer you out to resources we might have. We have our weekly webinars, such as this one here. And of course, we have our CDFI program, where we provide microloans to small businesses, as well as personal loans to those in the community. And now I would like to allow Bill from NBCLC to go ahead and begin his presentation. Thank you so much for being here today, Bill.
Thank you. Thanks for inviting me. Hi, everyone. Nice to see you all today. Let's see. Oh, I do need the screen sharing there to get started. Again.
I went ahead and gave you.
Okay. Very good. Thank you. Let me go here and let me get my PowerPoint. All right. Very good. Hold on just a sec. Let me just get this a little bigger and start it from the beginning. Here we go. So can everybody see that? So good? Yeah. Okay. Yeah. All right. Very good. All right. Well, folks, welcome to today's workshop here. Contracts is something that, is such an important part of small business life, and many folks use written contracts. A number of people also use handshake contracts, things like that. And so today's session, what we're trying to do is just help you feel more comfortable using contracts in your business, and of course, giving a little bit of a preference to written contracts as well, just for reasons we'll explain a little bit later. But here's the agenda I was thinking about. Okay, so contracts. Why do we use contracts? How do you make a contract? There's actually sort of 3 steps to making a contract there. Then this is probably the most important part, I guess I would say, is want you to go away from this session not feeling less intimidated by contracts. So we're going to give you sort of a preview of the most common things that you can expect in contracts, the kind of common concerns of the 2 parties that are entering into the contract that are usually in there. And then some language, some sort of general legal language that you might expect as well, so that you won't get snowed by it and just sort of go, oh no, I have to get an attorney to look at this. Well, you might need an attorney sometimes with more complex contracts, but there's lots of contracts that you can probably get to the bottom of yourself. And then there's also this aspect of contracts toward the end called the boilerplate. The boilerplate is what are terms that are virtually in every contract, just so to the parties, get treated fairly. And so what I want to do is go over at the end, what are the boilerplate rules that generally go with every contract? And then, of course, how to enforce contracts. what if a promise isn't kept? What do we do then? All right, well, so we'll cover that real quick. And then I also thought I'd introduce you to some of the more common contracts that are used by small businesses. And these are, just a subset of those. I picked out the ones that our clients in the clinics seem to use the most. And we'll go over each of these: the independent contractor agreement, the NDA, maybe you've heard of this NDA thing, a licensing agreement for intellectual property, copyrights, patents, things like that, to be able to use copyrighted material or patents. Commercial leases, many of you probably already have entered into those. I want to give you some highlights there. Founders agreements. So this would be if a group of people were getting together to do a business, there may be some things, terms that you want to work out at the beginning, just so that everybody, has their expectations met going forward. The restricted stock agreement is the way that in a corporation, a founder basically is set up as a part owner of the corporation, or other people are brought in to be part owners of the corporation and having stock in that corporation. So we thought we'd go over a little bit about what those agreements look like. A promissory note, this would be a loan that you would be getting from somebody. And finally, website terms of use and privacy policies. These are particularly important, of course, if you do any kind of transactions with users through your website there. So I'll basically have a slide on each of those agreements just to sort of highlight what's important about them and what are some of the key terms that you'll want to get. Now, all of these agreements are available from NBCLC. All you need to do is maybe put into the chat that you'd like to get a copy of one of these here, and I'd be happy to send that to you if you, of course, add your email as well. And then overall, I think Sandra might have said this already, but just we're going to go through the PowerPoint and then I'll answer questions afterwards. So if you have questions, go ahead and put them in the chat, because that's where I'll turn to first after the workshop is finished with the PowerPoint. Okay, well, the last thing just to note, as we always do, this doesn't substitute for legal advice, of course, because we're not talking about your individual situation. This is just general information about what legal issues are common to businesses, small businesses. But of course, we are available for individualized advice, which we always recommend. So do stay tuned for the last slide, where we'll give you some contact information, or you can always check with Sandra or FAHF about how to get in touch with us and sign up for our office hours, usually through our website. All right, well, let's go. Why use contracts? Seems sort of obvious, but just so you know, successful entrepreneurs are really managers, I think, of many different relationships. Okay, and so what we'd want to turn you on to here are that most of those relationships you're going to be having and managing will require some kind of agreement, and normally and recommendedly written agreements in that regard. But here, just a sample of some of these. So between founders. So first on the left is sort of the key relationships that we're talking about. And on the right is what agreements might be good to cement those relationships going forward. So here you got founders. Yeah, usually those are brought together in partnership agreements, or if you have a limited liability company, what's called an operating agreement. Sometimes there's just a straight founder agreement because you haven't figured out what type of entity you want yet. Okay, well, that's all right too. We can get that done. We'll show you a little bit about that. And then these restricted stock purchase agreements, that would be, again, for a corporation. If you were starting to sort of buy in and be a shareholder in the corporation, you'd need what's called a restricted stock purchase agreement as well. Workers, yeah, if you got workers, well, I'd say first, if you have employees, sometimes you would use employment agreements, but generally speaking, with employees, you don't want to have an agreement. You want to employ them on what's called work for hire basis. That means that you can walk away from the relationship at any time. Your employee can walk away at any time, but you don't cement that with an employment agreement. The employment agreement is basically for somebody who you don't want to be able to, you don't want them to walk away, and they want to expect that you're not going to just fire them at any moment. So there are specific employment agreements. Those tend to go with like CEOs or stuff, key employees, but otherwise you're generally wanting to use something called an offer letter, which just sets out the terms of the employment, and the employee then checks a box or something on it saying, I've read this and now I understand what my offer and what my employment's going to be, but it doesn't actually form an agreement with the employee that will lift you out of work for hire. See, we can talk about that more if you have a question on that. But more often when you're hiring workers, you're using independent contractors. You may be using independent contractors. And in that kind of a relationship, of course, has to be in writing as well to be valid. Then you got capital arrangements, loans. So this is where your promissory note might be used. Stock agreements, again, for getting stock in a corporation. Maybe you have a grant of some sort. Maybe you have a debt that will actually convert into shares of the company over time, or at a triggering event. Again, all of these are really important to have in writing there. Supplier agreements. So, how many widgets am I going to buy? When are you going to deliver those muffins for me? That sort of thing. And then you got your commercial leases, of course. That's a situation where I guess your supplier is your landlord, the supplier of your space. Then one thing you should definitely know is that insurance companies, they live through contracts. Every bit of what they will do with you in terms of service and backing you up is in the agreement. And essentially, you don't go outside that agreement. You want to make sure everything in the agreement reflects what you do, so that you'll know that you are covered or not, but before something happens. And then finally, you might have agreements with consumers. Many people do commerce over their website. And so in that regard, you should have these what's called terms of use or privacy policies on your website. We'll talk to you again a little bit about what should be included in there. But then, you might have a sales agreement with a consumer. I wouldn't say those tend to happen with like food retail or something like that. It's more like if you're buying a piece of equipment or a car or something that has some promises that goes with the agreement. Not just that here's your burger, it's a tasty burger. No, it would be like, here's your new computer, here's everything you can count on in terms of the computer, and here's what happens when it goes wrong, or something like that. That would be a place where you'd want to have an agreement, a written agreement. All right, well, let's go into again, why do we use contracts? It's because some things might go wrong at some points. And those people on the right are often what will happen. And when those things happen, you'd want to be able to look at the contract to say, okay, how are we going to figure this out? And who has what rights, and what goes wrong? What happens? Maybe there's some dispute resolution measure that we've agreed to, things like that. All right. Finally, I guess there'd be a question of, do I need a contract with my friends or my family in some fashion? Well, it may seem like we're being overly formalistic, but, it's not about trust. It's not like, oh, no, I need an agreement from you because I don't trust you're going to pay me. No, that's not it. It's that people forget. They're human beings. They will forget what the terms were that they agreed to. And it could be, oh yes, I will buy this from you, but you forgot to say something about when, or, how much down payment is going to be done or something. So again, these are things that should be set out beforehand, just so that, expectations aren't frustrated on either side. But there is this other aspect that you should know about, and that is an agreement also shows to people who will invest in you or give you loans like banks or stuff, they want to see you using written contracts. They don't want to see any kind of like oral promises that aren't sort of backed up in writing there. So, it makes you look more professional when you're going for those kinds of capital support. All right. Okay, so now let's talk about how to make a contract. Okay, there's basically 3 steps to it. Okay. And the first thing, of course, is the offer. So let me see if I give this to you. Okay. I'm going to offer you, oh, my croissant here. I've got a croissant. Oh, nice croissant. I'm going to offer this croissant to you for $5. $5 for the offer. Okay. Now, if you say to me, if you return to me and say, well, yeah, that looks pretty tasty, I'll take it. Okay, well, that's what's called an acceptance. You have accepted my offer on the same terms as I gave it to you. Yeah, I'll take it for $5. Sure. Okay. But let's say you think it's a little high. You say, I could probably get that for less. How about $3? Okay. Well, what you want to know there is if you make a counter offer, that extinguishes the initial offer. Okay. So in that situation, let's say that, let's say we did that $5 for this croissant. You said, no, $3. Okay. Well, at that point, I have the ability to just walk away and say, well, you didn't accept my offer on the same terms, I'm gone. But then afterward, let's say you then said, oh, I really want that croissant there. How about I'll give you the $5. Okay. Well, technically you extinguished my offer when you didn't accept it. Okay. Now maybe I held the offer open. Now maybe I said $5 and you have for an hour to decide or something like that. Okay. Well, then you could still have an acceptance or a counter offer or come back with acceptance within that hour that I gave you to decide, you see? All right, so offer and acceptance. All right. Now here's an interesting part is that's not enough. It's not enough because just promising to each other something that's going to happen, maybe, here's the thing, it could be distinguished from like a gift. Okay, why am I saying that? It could be that, maybe I just said, I'll give you this croissant for $5, and you said, yeah, but I actually have to give you the consideration. I have to give you the consideration, and you have to give me $5 to actually make the contract effective, you see. And so consideration is something of value that could be a mutual set of promises, I suppose, at the beginning. So let's say, you're going to cater my wedding for $500. Okay, well, you haven't given me the $500 yet, and the wedding isn't going to happen for another 2 months, but yes, you do have promises that can be enforced in that situation because there's a plan to give consideration. There's a clear plan to give consideration. Whereas in contrast, it would be, hey, could you help me with my reception at my wedding? Oh, sure. Well, what is that? There's no promise to do anything in particular except show up at my wedding and help. But you really need it cemented by some kind of consideration, some kind of down payment. I wouldn't rely just on promises of payment in that situation. Okay, now we'll talk in a minute about what's adequate consideration or stuff like that. But here's one other thing you should definitely know is that oral agreements, yes, oral agreements are enforceable sometimes, okay? Unless the agreement falls into one of these categories here, okay, like prenups. Prenuptial agreement has to be in writing to be enforceable. Paying another person's debt, that has to be in writing too. Interest in a property for more than 1 year. So you should know that if you're renting a piece of property, apartment, something like that, if it's less than a year, it actually doesn't have to be in writing. Should it be in writing? Yes, absolutely should be in writing. But somebody could potentially set up that kind of an arrangement for less than a year with it being outside of writing. Okay, and here's another one. Agreements that cannot be performed within a year. All right, what does that mean? Well, yeah, if I contracted for you, to cater my wedding. By the way, I've been married for 30 years. I'm not going to have a wedding, but let's say, oh, here you go, our anniversary party. Okay, you're going to cater my anniversary party. And we're going to hold it next January the 10th. Okay, well, and I don't mean this coming January, I mean next January the 10th. Okay, that agreement can't be performed within a year because it's a year and 20 days. So in that situation, that would have to be in writing to be enforceable. All sales of goods over $500, 500 or over, has to be in writing. Okay, again, always recommended to put things in writing, but sometimes you can get away with oral agreements if it doesn't fall into one of these categories there. All right, so let's just say a little bit more about offer and acceptance. We're talking about a meeting of the minds, okay? And there was an interesting case long ago that showed this. It was actually a supplier who was waiting for, I can't remember what it was like lilies or some kind of like perishable good or something like that. And it was supposed to arrive on a ship named the Johnson, okay? The Johnson was supposed to dock into port at a particular date. They had this all set up. It was ready to go. The Johnson was coming into the port, and the supplier trying to get the lilies goes to the dock and is like, "Oh, great! Here's the Johnson. All right, where's my lilies?" And they're like, "Lilies? What do you mean lilies? There's no lilies on this boat." And they were like, "What? Wait a minute. We contracted the Johnson, the lilies. What's going on here?" Well, it actually turned out that there were two ships named the Johnson. And so what the court said in this situation was, look, this was a reasonable mistake on the other's part because the other Johnson went to another port instead, and there was a misunderstanding about which Johnson boat was being contracted for. So in that situation, the court said, well, there just wasn't a meeting of the minds on it. Okay, you got to be very clear with each other so you're thinking of the same thing going forward. All right. Parties must intend to be creating a contract and show that they are. So again, if I just said, here's my croissant for $5, who's going to take it? And you're just quiet and silent, that doesn't create a contract because you have to show, that intention. Maybe you said, well, I really wanted to, and I kept trying to, signal you with my eyes or something like that. That's not going to do it. You see. All right, two other little exceptions. Okay. You must agree on the main terms to create a contract. So here's an example. Yeah, that 30-year anniversary for my wife and I. Yeah, I want you to cater that next January 10th. Okay, agreement. We're good? All right, that's fine. Well, if you then decided later, gee, I'm not going to be available at that time, and you tried to break the contract, a judge may well say, well, wait a minute here. Okay, you said January 10th. Okay, we've got a date. Okay, now we know the time when it's being delivered, but what was involved in, I mean, you're going to have this kind of food or that kind of food. How much is it going to be? It's possible that a judge would look at that and go, look, that wasn't a good contract. That wasn't enough of a contract because there weren't terms that are sort of usual in a contract like that. So because those terms weren't in there, we're not going to enforce it. All right, so just make sure that sort of the key terms are in your contract there. All right, so here's this in consideration. Again, you're going to cater my 30th anniversary for money. Yes. Again, down the way, it's probably going to be better if you put some kind of down payment down there so it's clear that you have given some consideration for something like this. But normally a court, again, if it's more specific, you'll prepare this kind of food and it'll be at this date again, and it'll cost this much. Well, that looks a little bit more like, yes, you've made enough of a promise to pay that'll be enforceable too. Okay. But here's a couple other things. Past acts don't count. Okay, what does that mean? I saved your dog from drowning. Okay, 2 years ago, right? I saved your dogs from drowning, and you said, "Oh, let me give you 50 grand or something like that." For well, it's a pretty good dog. Let me give you $500. Oh, well, that's so nice of you. Well, no, I just wanted to save the dog. That's fine. Okay, but then 2 years later, I come back to you and say, you know what? I'll take that $500 that you were going to give me. I really need the money and all that. No, sorry, past acts. If you didn't collect at that time, not going to count, right? Pre-existing duties don't count. Fireman carrying you out of a burning building can't then turn to you and say, I could use a little money for the rent, but no, you can't do that because they had a pre-existing duty. as a firefighter to carry you out of that building there. Okay, so that does not count for consideration either. And here's the last thing I'd say is usually the value of the consideration is not really that relevant. It's just if you have some consideration there. So this is why, you know, like as an independent contractor, you could agree to work for $1. You know, $1 would be enough consideration going forward here. Sorry, dog's a little loud there. I'll keep going. So just, you know, oh, here's one other thing that often happens. So let's say you're an employer and you got employees, let's say they're under contract in some fashion. Okay. You then say something like, well, oh, you know, I forgot to put a non-disclosure agreement in that. You know, I have a, I'm sorry, doggies are out here. Oh, goodness. All right, guys, that's enough. Quiet. Here you go. Go. No. Sorry, evil mailman at the door. Okay, anyway, so here's the scenario. Have an employment contract with you. You're going to work for me. This is great. Oh, I forgot to put in the non-disclosure agreement. Okay, could I just go back and say, gee, there's this other part of the agreement. I forgot to put these terms in there. Is it okay if you just sign these? Well, you might get them to sign it. The problem is there would be no consideration in that situation. They didn't get anything new. They didn't get anything of value for you just adding on this new term. So again, the fact that they agreed to this arrangement here, if you want to change the agreement in some fashion, usually you're going to need some additional consideration. Maybe, you know, in that situation, maybe you'd say, well, how about 3 days of paid vacation per quarter instead of 2 or something like that. Yeah. Okay, that's how you create the contract. Offer, acceptance, and consideration. Watch for those counter offers, okay, that will potentially extinguish the offer. But offers may be held open for a period of time so that then you will have time to consider them and accept them or turn them down. All right, now we're going to talk about reading contracts. We're going to talk about, you know, these very intimidating pieces of paper that often come your way and you just go, oh goodness, I just I wish I knew how to read these things. Well, that's what we're going to help you with a little bit, okay? So here you go. One thing you should know is that there are terms that are usually found in every contract. So one of the first things you can think about if you feel like you're being snowed by a 30-page document is you could just sort of go on a treasure hunt, okay? And what I mean by that is start looking for these kinds of terms. Okay, what does the agreement do with money? Okay, what does the agreement do with risk that is involved in the contract? Somebody gets injured or there's risk that the job won't be done in time or something like that, okay? I'll give you the factors here first and then I'll give you some examples of them. So again, look at the agreement, see what it does with money, see what it does with handling the risks involved for the two parties. Ooh, here's another. See what it does with the control that's potentially being taken on or given up in the relationship, all right? There's this thing that you often see in contracts, it's sort of mushy language, standards that will be used for particular promises in the contract. Well, I'll tell you what that would be in a second there, but, you know, look for words like, you know, we will pay you within a reasonable period of time or something like that. Okay, well, that's a standard. All right, I'm going to pay you within a reasonable period of time. If you see things like that, you might say to yourself, well, is that defined enough? I mean, what's a reasonable period of time? I mean, see, that's where in a negotiation, you might want to say, you know, hey, let's define this. Yeah, I got to pay you within 10 days or something like that. All right. Finally, the beginning or end of the contract is usually pretty important too, especially because some contracts don't actually seem to end. You know, if you have a commercial lease, for example, and you don't cancel it, if you don't terminate the lease before the particular time period built into the lease, it will just keep going. It'll be rolled over into new, you know, a new lease term going forward. So it's important that you pay attention to when the contract actually begins and when it actually ends. And here's what I'm talking about for each of these here. Okay, so money. Yeah, how much is being talked about? When are things being paid? Okay, risk could be another one. Who's on the hook if something goes wrong, if somebody is injured or something like that? What'll happen if the supplies, those lilies didn't come on time on the Johnson there? Who takes the risk of that sort of thing. Control, who has decision-making power in the agreement? So for example, here you go, commercial lease. The tenant is given the power to extend, usually. And so at that point, you have a certain period of time within which you can extend. That's your decision. But then after that period of time lapses, then it's no longer your decision. It's the landlord's decision as to whether to let you stay going forward. Okay, standards, as I said, vague or missing terms. Another things you'd think about would be like in a lease. It would say something like, well, tenant will not disturb the neighbors. Okay, well, what does disturb really mean? Or at the end of your lease term, you're going to leave the apartment broom clean. Okay, well, what does broom clean mean? Okay, so some of these terms, may be fine going forward, but I guess I would say just watch out for those kinds of terms because they're a little wishy-washy. Expectations can get, frustrated if things aren't very clear. And then, as I said, beginning and end game, when do the terms begin and when do they cease? All right. So if you just looked in the agreement, again, on sort of a treasure hunt, looking at this sort of stuff, then you're already very far along in embracing what the contract is all about, or more specifically, embracing the key terms that most people care about. Okay. So this is one. Now, another thing are these basic, you can't quite see my screen here. Oh, there we go. The 4 basic contract drafting tools. Okay, what am I talking about there? This is language that is often included in contracts, legal language. And when you see it, you should just know, how would I say, you shouldn't be surprised. You shouldn't be saying, oh no, a lawyer has to help me, look this over. Instead, here you go, a representation. Okay, a representation. Here's another. Well, okay, let me put them all out there and then I'll cover it. Representations, warranties, covenants, and conditions. Okay, what am I talking about for each of these here? All right, let's take a used car example. I'm going to buy your used car. Okay, what's a key thing you might say to me about it? This car has 50,000 miles on it. Okay, a representation is a statement of fact that is shared by one party to agreement to try and induce the other person to enter into the agreement. So I'm not going to buy your car until I know how many miles there's on it. Oh, you told me it's 50,000 miles. Okay, well, that's good. Okay. I have the ability to rely on that representation going forward. Okay, here's another one, a warranty. Okay. Essentially, a warranty is a promise to back up a representation. Okay, so this used car is in good condition, good working condition at the time of sale, but if it broke down within 90 days, the buyer can void the sale and get their money back. Okay, so that's trying to say, okay, look, I'm saying to you, this is good working condition, but if somehow my promise, my representation is wrong, then something else will happen. You whole here by giving you, your money back here. Okay, so that's a common thing too, is a warranty would be in there. A covenant and is simply a promise. Okay, seller agrees to sell the used car to the buyer for $10,000. Well, if there was nothing else in the agreement, that's a pretty straightforward, I agree to sell this thing to you for 10,000 bucks. It doesn't maybe have enough terms in it. Well, I don't know, maybe enough if you can identify which used car it was. I guess the court would probably fill in, you're going to make this transaction happen and within a reasonable time. Buyer, if it doesn't say otherwise, $10,000 is going to be paid when the car is exchanged, that sort of thing. But this is where conditions come in, you should just know. So conditions are promises set in time. All right. So when you're buying a used car, generally, here you go, you generally want to say, well, I'm not going to give you the keys and I'm going to transfer the title. I have that responsibility myself. I promised I'm going to do that for you, but I don't have to perform until you give me the full purchase price. Or maybe it'll also say, and you get to take the keys temporarily so that you can take it to a mechanic to check it out. And then if the mechanic is satisfactory, then you come back, you pay me the full purchase price. You then keep the keys, I transfer the title. You see, so all of these promises are set in time. And so, for example, you get the keys, but you never go to the mechanic. Well, then now our agreement is kind of, I don't have to perform to get the title to you. And in that situation, I'd probably say, give me back the keys because you haven't performed yet. Okay. And I don't have to perform until you perform, you see. Okay. All right, so those kinds of conditions or promises set in time are also kind of important to figure out, just because then, sometimes a promise to do something is a condition precedent. I mean, you are going to do something and then I have to do something. You're going to buy me the paint to paint your house and then I'm going to paint your house. Okay, if you never buy the paint, I don't have to, it's not a breach for me of the contract to not paint your house because you haven't performed yet. All right. Finally, there's boilerplate. This is what many people sort of say at the end of the contract. Oh, there's the fine print and it's going to screw me over. Well, no, actually, what's interesting is once you get to the end of the contract, it usually says something like general terms or miscellaneous terms or something like that. And then you start seeing these headings here of what they're talking about. Okay, you should just know that these are terms that everybody agrees to. Okay, they're just like to help the agreement happen, and if there's enforceability or if there's some questions about it, this is the way we're going to cover. We're going to resolve things. All right. So the first one might be a dispute resolution mechanism. It might say if there's a disagreement on this agreement, then the parties agree to go to mediation. Or the parties agree to negotiate in good faith or something like that. Again, these are sort of guidelines that usually go with contracts and most people agree to. And we'll cover some things about mediation or litigation later. We'll cover what that means and stuff. All right, here's a very important one. It's called the integration clause, or sometimes it's called a merger clause. And what this means is, okay, I've entered into this written agreement with you, and it represents the entire set of promises that we have agreed to. Okay, so what this means is that if you have an agreement, if you look this thing over and you say, wait a minute, no, we promised that, this sale wasn't going to happen until next month. Not now. All right. But did you put that in the agreement? Is that in writing? No, it's an oral agreement. You told me that you would only enforce this agreement next month. Okay, well, those side oral agreements, when you see this merger clause or integration clause, are not going to be considered. It's essentially saying if you want to have that term, you had to be in the written agreement going forward. Okay, so that just means watch those oral side agreements. They're usually not enforceable. But do read the contract over totally, make sure all the promises that need to be in there are in there. All right. Modifications, yeah, generally speaking, both sides have to modify in writing. Okay. There are these things called waiver, though. Waiver would be something like, okay, yes, I see in my lease I have to pay by the 10th of the month. Oh, I'm sorry, my reimbursement's not coming in till the 11th. Can I pay you on the 12th? That's where I might say, okay, sure, this month you pay on the 12th. But that's what's called a waiver, and it's not effective forever. It just means you've waived this term. You haven't modified the contract. It's just, I'm not going to enforce this one term for this one occasion here, you see. But modifications would be altering the contract, long-term going forward. And again, both parties generally need to agree to that in writing. Assignment, yeah. So let's say I want to buy Sandra some Taekwondo lessons for Christmas, and I say, okay, my friend who is a Taekwondo master, hey, I'm going to, I'm going to buy your services and you give some Taekwondo lessons to Sandra. Okay. But then the question here is, could the Taekwondo master actually assign it to one of his students? Well, no, because it's not the master. I wanted somebody with the, the best skills in this area for Sandra to learn from. No, generally you'd want to put in your agreement that there's no assignment of the rights in the agreement. Okay. Similarly, Sandra could say, well, here's an interesting thing. There's this thing called a third-party beneficiary kind of an agreement. What does that mean? That means that if we took that same scenario there, I said, oh, hey, Taekwondo master, I'm giving you money. You're going to teach Sandra. If Sandra knows about that arrangement and agrees to it, well, then she can also be an enforcer of the agreement as a third-party beneficiary. If in the agreement it contemplates, it says Sandra knows that this is going to be an agreement that she is party to. Okay, well, so if that master decides to assign the agreement to somebody else, she can say no instead. It doesn't have to just be me who gave it to her, you see. All right, so those are some terms that generally you should have an agreement about who can either perform the contract or get the benefit of the contract going forward. Okay, some of these are pretty straightforward. Governing law, which states will govern. Generally, if you're in California, California law will apply because it's out there to protect consumers and stuff. Notice, it's probably important to say, okay, well, if something goes wrong with the contract, who do I contact about this? Okay, that's an important part. Severability, this is a portion where sometimes, people will enter into contracts and there'll be a portion of the contract that actually isn't enforceable. Here's a good example. Let's say that you hire somebody and you say, well, you know what, after you work for me, you can't do the same business. You can't compete with me anymore. After I let you go, you can't compete and do the same kind of business. That's what's called a non-compete clause. And it's actually illegal in the state of California, generally. To put those kind of constraints on somebody. Okay, well, in my employment agreement with you, just the fact that that's an illegal provision doesn't mean that the whole contract falls. It means that if it ever came to court, a court would just say, okay, look, that portion, that non-compete, that's not enforceable. We're going to take that out. We're just going to edit that as though it never existed in the agreement, but the rest of the agreement's going to be okay. Just a couple more. Force majeure. Force majeure, boy, this came up a lot during COVID. It was, look, if there are things that you just can't anticipate, and it causes one party to not be able to perform on the contract, we're just going to sort of say, look, that's just sort of out of the box. We're not going to find a breach. Here you go. I agree to paint your house. Okay, well, your house burned down or somehow the water main broke and so nobody can go in the property at all. Something happened. All right, well, those things happen, and so I wouldn't be held liable for coming and painting your house because this is something that none of us could have anticipated. Usually these force majeure clauses are in agreements there. Oh, and I already covered the waiver about that, like waiving when payment was due. Okay. All right, so these terms, just know when you're looking in a contract and you get to sort of the end, like the last 3 pages or maybe the last page, general terms, miscellaneous terms, these are terms that are going to help you. They're not going to be a problem. Just make sure that, in fact, you would probably be relying on some of these things too, like that there aren't any oral agreements or stuff. So just make sure that if you see those in there, you'll say, oh, okay, good, boilerplate, helps me. That's great. All right, now here you go. What if somebody breaks the promise, breaks their contract or stuff? Well, there's a few things you can do. What we usually recommend is negotiation, or at least trying negotiation, because judges always, if you ever get to court, a judge is always going to want to see if you tried to work things out. And you should also know that, like, for example, I was leaving a tenancy, this place. The landlord decided to keep the entire security deposit because of alleged damage. And I just said, no way. You know, I took pictures, I showed, you know, none of that damage really happened. So I took him to small claims court. And here's the point is 80% of cases are usually resolved by the parties on their own. We resolved it the morning of the court case because usually people, you know, as they think about it, they go, oh, I don't really want to go in front of a judge. It's kind of a crapshoot. Maybe the judge won't like me. You know, I better see what I can do without, you know, that I can control, an outcome I can control. But again, negotiation, a good idea to start doing that before you go, you know, higher with like court or something. Now, there are some things before going to court that we would tend to recommend. Mediation. You know, there used to be an organization, I think down there in Fresno called SEED, I think it was. I don't know if they're still there or not, but I put that in there. There's another organization called JAMS, I think it calls Judicial Administered Mediation, I think it's called. Anyway, there's usually some free or low cost mediation services that you can get. And what is distinguishing this from arbitration, mediation, arbitration? It's just this one little thing, and that is a mediator can help you reach an agreement. An arbiter in an arbitration can help you reach an agreement. However, if you don't agree, a mediator cannot enforce, can't say, okay, I've heard the two sides. I think this is the best outcome. I'm ordering this outcome. No, an arbiter can do that. An arbitrator or an arbiter, again, a trusted middle person that then the parties have said, okay, we will abide by your decision. Okay, that's an arbiter. All right. What happens is if the arbiter makes a decision, then the parties are also under agreement that one of them, the winning party, gets to take that to court and actually have it put into a judicial order, so it has the force of law. Okay. All right, so finally, we got a lawsuit, generally not recommended. Well, small claims court is recommended because it's, you know, kind of quick and easy and no lawyers are involved, but there are limits, okay? If you're a sole proprietor or an LLC, you get to put in, or excuse me, a sole proprietor or a single person can sue for up to $10,000. If you're a corp or a LLC, you're limited to $5,000. Again, no lawyers are involved, so that's usually a good thing. Usually low cost, you just show up, put in your written evidence, judge coaches you on how to do it, you know, and usually then looks out for the interests of both parties because they're not represented. This is in big contrast to state superior court in California, which I would say generally is going to cost you at least $1,000 to litigate anything at all. And it's usually going to take months to get through that case. And while you're doing your business, you know, do you really need that stress and the potential big payment at the end or big payment for the lawyer beforehand? So I guess what we'd say is definitely think about the one at the bottom. If you can't negotiate or mediate, you know, lots of time involved here, not something to undertake this lightly. You know, small business usually doesn't have time for you to be involved in litigation going forward, but maybe you're a defendant, so you have to do that anyway. So, all right. All right, well, this is the end of what I got here. And this is our contact information. Now, if you want to stick around a little bit longer, you know what I'll do first is, let me go back. What I'll do is I'll check the chat. Oh, somebody just came in. I'll check the chat for questions that people might have. And then for folks who might want to stick around afterward, we will go over these agreements, those common contracts that businesses use. Again, I have a slide for each of these so that you just get a sense of what is sort of important to look for and what the agreement does, okay? But let's handle the basic questions first, okay? But before we do that, just want to flag, okay, if you want to sign up for our services, go to this website here, www.law.berkeley.edu, NBCLC. That's where you can sign up for these office hours that we do every week, Mondays and Wednesdays. We do 3 hours of office hours, hour-long appointments for each office hour person, each entrepreneur that signs up. It's free. It's only if you can, you know, it's basically only for people who can't afford a lawyer. And we can usually help you with, you know, a few questions, maybe give you a form that you might be looking for, but it's not for sort of several months worth of legal assistance. Let me say that. If you want to get into that, we do take on a few clients on a regular basis that we can work with over a 3-month period. That one you probably want to email me and I'll give you an application for our services. So email us at newbusinesslaw@berkeley.edu to get involved in that. And finally, we have this online legal library for entrepreneurs. It's called OLLI, Online Legal Library for Entrepreneurs. If you go to ollilegal.com, there's a lot of free resources there, things, articles explaining stuff about the law. It's just very useful information that should be helpful for you. So, oh, and do check us out on Instagram and Facebook. All right. All right, so let's stop the share for a second while I check for some questions, and then we can go to that second part of the workshop there. Let's see, where's the chat? Oh, I don't see any questions. Okay, well, why don't we do this? If anybody does have questions at this point, please unmute yourself and speak up. That'll be fine. Go ahead. Questions? One of you, Jocelyn, is connecting to audio at this point. Well, I guess what I would say is then if people don't have questions, why don't we finish up this last little part here with the individual contracts that might be useful for small businesses. Can you see that now? All right, so let's go forward with that. All right, as I said, these are the most common agreements I would say that our clients use in the small business clinic, or the most ones that people ask us for and stuff. And again, any of these, I can send you one. Just put in the chat your email and say what kind of agreements you'd like to have, okay? All right, well, let's start. Independent contractor agreements. Well, what you should know about this is that independent contractor agreements are now governed by, oh, it looks like somebody's in the chat. Okay, good. Oh, somebody's dropping off. Okay, thanks, Deb. Thanks, Dee Dee. Yeah, thanks for joining in. All right, so independent contractors, here you go. There's this new, well, a couple years old now, California law called AB 5 and superseded recently as AB 2257. It essentially tries to deal with the fact that so many independent contractors have been misclassified in the state of California, not the least of which by Uber and Lyft, who have made drivers who would normally be required to be employees into contractors. And there's still a lot of debate, and even though they did this public referendum to try and lift themselves out of this new independent contractor law, it still may not work for them, just because the state of California says, hey, look, you know, employees deserve stuff like overtime, and you know, if you're going to control them a lot, well, then they should be employees. You know, if you have to put your logo on their car or something like this, and you have to use your app to get jobs, and you can only go, you know, charge these certain rates. That's a lot of control, and that is one of the first things that is a problem under this new law. It says, look, independent contractors generally must be free from the hiring entity's control. And so if your employer is, you know, saying, sit at this desk 9 to 5, wear our uniform, you know, that sort of thing, that can't be an independent contractor. That's got to be an employee going forward. Okay, the two other aspects are that the worker has to perform work that is outside the usual course of the hiring entity's business. So, you know, not surprisingly, a daycare center teachers should be employees, because that's the service that the business is holding out for the public. We're going to give you daycare, you know, good care, and our teachers provide that. So the teachers generally should be employees there, you see. Independent contractors need to be in business for themselves. So all three of these aspects have to be true in order to hire a valid independent contractor in the state of California. What does this mean? Okay, well, independent contractor in business for themselves. Do they actually have to work for others? No, but they have to hold themselves out as that they're working for others. So like a plumber. You know, plumber is going to come to your place, do the plumbing, and then go work for somebody else. Okay. And by the way, that arrangement satisfies all three of these things. You know, I'm going to come in, you just tell me where the drain is, I'm going to plumb it. Okay. You're not standing over me, telling me, showing me how to do the plumbing, and you're not giving me a plunger. Okay. And, you know, your business is not, you're doing a food business, you're doing something else, you're not in the plumbing business. Okay, so I can come in, it's outside the usual course of your business, and I can unplug your drain, you see? All right, well, here's the main thing is there's big liability for misclassification in this situation. You should just know if somebody was classified as a contractor, but they should have been classified as an employee, they can go after you for 4 years after this happened. Okay, so it's a pretty big thing, and you should just know that you're going to be seeing more ads on the late night TV saying, do you think you were misclassified? Come and talk to me because we can get you compensation. Well, so be careful here. Now, in the independent contractor agreement, just a couple other things you want to make sure that are in it. All right. So let's say somebody is an independent contractor doing your website. Okay. Well, you would normally think, well, gee, here's first, it's going to meet all 3 of the ABC tests here because I'm just telling you what the website needs to look like, and you're going to produce it for me. I'm not going to show you how to code it or anything like that. All right. And you're going to put it in, you know, as of this date. Okay, well, that's a little bit of control, but not too much control. I don't have anybody on staff to do this website, so it's outside the usual course. And oh, and you set up websites for other people. Sure, okay, this is great. So you've identified all 3 of those things. Okay, now here's the thing you might think about is they do the website for you. They say, thanks, you pay them. Is that your website? Not necessarily anymore. What you need to have in your agreement with the independent contractor is, hey, at the end of this job, I'm giving you the website, the code, everything that goes with the website. It's not going to be mine anymore. All right. So there you go. You're a photographer. You're taking pictures for a newspaper. Okay. I'm going to give you the pictures afterward. It has to be in writing. It has to be in a written contract. Make sure you have the ownership of the thing, the content they're creating for you down in writing. And then there might be some liability issues. Yeah, like I have a contractor building my house. Well, you know, if the roof caved in, what's going to happen? Well, maybe you should have in your independent contractor agreement what happens if something goes wrong. Probably they need to have insurance and back you up and stuff. All right, this is one of the bigger ones. Now, these other ones will probably go a little faster. You can't quite see there. Non-disclosure and invention assignment agreement. Okay, what is that talking about? So a non-disclosure agreement allows you to share information with somebody. You know, sometimes it's just, hey, I'm going to share this with you and you keep it quiet. You don't share it with anyone else. Or it could be, hey, the 2 of us are studying whether we want to go into a business relationship together. So you're going to disclose some stuff to me. I'm going to disclose some stuff for you. It's a mutual NDA. Okay. So there's 2 different kinds like that there. And sometimes you should also, you know, the standards forms usually define very broadly what would be confidential, what has to be kept confidential. But if you have something specific, definitely include that in the definition of the agreement, what is confidential, what needs to be kept confidential. And then here's probably the most important one is define the purpose for the disclosure. Why is that? Because, and this is what happens, you know, you are disclosing something to somebody so that then they can give you a price, let's say on a prototype that they're going to produce for you. Okay, well, the purpose is only to explore whether, you know, they're the right person to produce the prototype. That means that they can't then take what you disclose to them and run with it, because that wasn't the purpose of why they got the information in the first place. They can't just run and start using it and stuff like that. That would violate violate that agreement that you have with them. Invention assignment, usually a couple of terms in here, like let's say you had an invention, somebody got a patent, or maybe they developed something that could be patentable. The inventor has to cooperate with you, if, you know, again, these are terms you want to have in your agreement, to actually secure that patent going forward. Okay. If you're registering a copyright, they need to attest on the copyright transfer that they gave the rights to you, you see. Usually the inventor should give you some kind of warranty. Again, remember that is a representation. I am the sole owner of this content. And a warranty would be, if I am wrong about that in some fashion, here's an indemnification clause here, indemnity. If somehow, oh, I said this was my content, oh, it actually turned out to be somebody else's and it caused you damage. Maybe that person sued you for copyright infringement or something. Okay, so that what should be in the invention assignment. And then I've told you a little bit about NDAs here. IP licensing agreement, this would be for the transfer or the use. Excuse me, what am I talking about? Licensing is the use of the content or the patent or something like that. And in this written agreement, you usually, again, want to have this in writing, and you'll want to have it define a few things like, well, what geographic area can you use this copyrighted or patented piece of content in? And how long do you get to use it? And are you the only one who gets it, or can you actually assign it to somebody else or sub-license it to somebody else? Those are things you definitely want to address in your licensing agreement. Again, here's some of those warranties, before, getting licensing or getting something from somebody, I'd want them to say, well, I actually am the sole owner and can give you these rights going forward. Usually there's 2 fees involved in this licensing agreement. So there's just this fee to license and use the content involved, the intellectual property involved. But if it creates income for the user, well, that's what's called royalties. And so often what'll happen is, okay, you got this. I give you my patent here. Okay, the patent, just for you to use the patent, it's going to be, I don't know, $20,000 a year. And yet, if you make money off of it, I get a percentage of the royalties on that. So that's what usually would be in there. Again, limitations on liability. This would be things like, well, how would I say it? Here you go. I've put this curriculum together, but some of this curriculum I've actually, the PowerPoint here, I've actually taken some information from some websites, with good information on it, a little bit here and there. If I gave this to you, I would say, well, you know what? If you're wanting to use this, I can't actually say that I'm the sole owner of it because it's got some content from other people. That would be my limit on liability, is to say I can't say to you that you won't be sued if you use this from one of those other people who helped develop it. All right. But you could say, well, give me some indemnity then. Okay, well, yeah, I'd say, all right, well, if that does happen, then I'll back you up with some insurance or something like that. All right. All right, commercial leases, here we go. You should just know commercial tenants don't get the same kind of protections as many, residential tenants do. And it's very much buyer beware in this situation here. Each landlord will tend to have their own lease, so there doesn't tend to be a sort of a standard lease. So you got to read it really carefully, and always, your power to get terms that you need is always the greatest before you agree. So always sort of look at those things that you absolutely need to have and include that in your negotiation, because you just won't be able to add it later, probably. Fewer things, the landlords may try and pass along costs to you that, again, you should negotiate out. One in particular is not just maintenance, but ADA compliance. So it may be that the landlord gave you a lease that says as is, or they maybe gave you a lease that says you will do whatever upkeep is needed to comply with local government requirements or national government requirements. That's where you would say, oh dear, I'm not going to sign that, because it could be that I have to put in a ramp or something like that for the ADA. Here's a few other things to just make sure you have in here. Is there anything on signage? Is there exclusivity in terms of entryways, or are you sharing that with somebody? Is there parking? Are there improvements that are going to be made by you, by me? All of these things need to be written down before you enter into the lease. And generally, these leases are long-term, like 10 years or something. So it's kind of hard to walk away. So be sure that you know how you can terminate or sublease. Usually, commercial landlord cannot withhold the ability to sublease unreasonably. Okay, so if you get another tenant like yours or something like that, and they show that they're good credit, generally a landlord has to allow them to sublease the property. Okay, but if you brought in, let's say, you have a storefront, retail food, but you bring in a I don't know, an ongoing trapeze camp. That might not be the right thing for that space, so a landlord could turn that down. And of course, a strong recommendation, have a lawyer review this before signing. All right, we're almost to the end here. Founders agreements. If you have a group of people who are coming together in a business, you can, there's lots of different entities you can form, corporations, LLCs, partnerships. And those usually have written agreements that go with them, like a shareholder agreement or the operating agreement there, okay? And that usually sets out the terms of the deal between the founders. But you could, before you form those kinds of entities, still enter into the deal with what's called a founders agreement, where you agree to certain terms. And we've put out here probably the 4 most common, most important ones. And that is, okay, who's going to be putting in money into this venture and how much, okay? How are the profit shares going to go? How much money do I get out as a founder, profit-wise, and when? Decision-making power, just the general management decisions. Do I get a voice in that? Do you get a voice in that? And then how do we bring other people in? Do I get to sign off? Do I have to sign off on people coming in? And how can I withdraw? So those are probably the 4 major things to address in any agreement, either the shareholder operating or just plain old founders agreement. Another important point is if equity is involved, I mean like shares of the business, ownership shares of the business is involved. Yeah, you got to make sure that all of the steps to issue those ownership shares are done. In a corporation, the board has to issue the shares. You actually have to set up this restricted stock agreement to have you pay some money to get your shares. Make sure all of those things are done. Okay? And of course, have a lawyer review before signing. Here's that restricted stock agreement I was talking about. So a founder, usually in a new company, is expected to continue to work for that company. You don't usually want to have a situation where you say, well, you get 20%, no, you get 51% of the company forever and ever. We just like you, you're going to be going places, you're doing stuff. Great. Wonderful for us. No, often you'll want to have a situation where you say, okay, you'll start at 20% owning, and then you'll work your way up to 50% owning over a period of time. That's what's called vesting. Right? And here's your standard vesting schedule there. 4-year vesting with a 1-year cliff. That means that you have to work at least for 1 year in order to earn 1/4 of the equity that you are and 1/4 of the shares that we're going to promise you. And then after that, every month for the remaining three years is going to be vesting, a little bit, you see. There is this thing called acceleration. What am I talking about here? Well, usually when people are setting these things up, they're not anticipating that like their business might be acquired, while things are still being vested. And this is a thing that protects you if, for example, let's say you were subject to a vesting arrangement here, but your company was bought in the first year. Okay, well, in that situation, it may be that if you have a single trigger clause in there, what that means is that as soon as somebody acquires you, then all of your shares and equity vests. Okay, it's just trying to protect you because the new person coming in could basically fire you and get, and you'd lose everything. But then there's this other thing called double trigger, which you can have in there. And that says essentially, okay, well, it's okay if you're acquired. That doesn't trigger the vesting. It's if somebody terminates you after your business was acquired, then yes, in that situation, you would also get your vesting at that point. Now, there's one other aspect here. I don't have time to go through it over there, but just know that vesting involves you getting stock over a period of time, and that little bit of value that you get with the stock over the period of time will be subject to tax. But there is this situation that helps you definitely. It's called 83B. It's a form 83B that you file with the IRS. And it essentially says, look, I'm going to have this vesting arrangement going forward. However, I'm going to pay all of the tax up front on all of these shares at a point where they're very low in value. So that way, when I get them as I'm going along, I'll already have owned, done what I need to do to own them, okay? And that means that I'm only going to be subject to capital gains tax when I sell them eventually, not income tax, which is a lot higher, you see. But if you don't do the 83B, then every little bit of stock that vests in you over like the 4-year period is going to trigger income taxes. And as you can probably guess, that stock is going to go up in value. And so that means that like by year 3, you are going to pay some substantial taxes on stock that you can't even sell to anybody because of the stock restrictions. So, all right. So those are some things just to think about. Securities compliance, just so you know, generally when you're sharing stock with somebody or shares of a company, they have to be either insiders or they have to be what we call accredited investors. That's because the SEC is very concerned that people in between, either the insiders who already know about the company or the accredited investors who are rich people, the people in between there could get ripped off if they aren't, getting the right disclosures and stuff like that. So generally they say, yes, only give stock out to insiders, people who are CEOs, maybe the family of the CEO, that sort of thing, or rich people. Then you have to file an issuance notice with the shareholder state, so California, if they're here, and the SEC as well. Again, always have an attorney review there. I think this might be the last one, promissory note. Oh, no, we got terms of use as well. Okay, promissory note, this is to set up a loan, of course. Make sure that you identify in there on the amount that's borrowed, the interest rates, just make sure you don't have like interest rates that violate California's usury laws. I think that might be like 29% is the usury law. Got to be below that. What's the repayment schedule? Maybe there'll be some collateral. You put up your car in order to get this loan or your house or something. And what happens in the event of default? Is there ability to cure it within a period of time, without going into full default? Usually it's wise to set up some kind of auto debt repayment so that just debits, you don't have to keep chasing the person all the time. And again, have a lawyer look at that beforehand. All right, last thing, guys, here we go. Websites, here we go. Now, the main thing with websites is that you have agreements with the people using your website. They're actually set by either having them click, I agree to the terms of use, or if you put it prominently on the website, and I don't mean like a little teeny type down the bottom, I mean like in the middle of the page, here are our terms of use, then a court will deem, either if they clicked it or if it was on the website prominently, that the people have agreed to the terms because they've, continued using it, okay? So here are a few things in the terms of use you might want to cover. No commercial use. Yeah, if you are doing a commercial business and somebody tries to use your business to, as sort of, reselling stuff afterward, yeah, you might not want them to do that. You might want to say, this is only for personal use. Right? A few other things you probably want to have is you have the right to modify the terms of use at any time without even giving them notice for any reason. That way, you're protected if you need to change things. Website is provided as is, that means that, it could close down sometime if the internet goes down or something happens, and you're not going to be responsible for that. That's where the waiver of liability comes in. Now, here's the important part. Be sure to account for all of the website's functionality. What do I mean by that? Okay, if you have people using the site and posting content like copyrighted material, like posting pictures or stuff, well, you got to be careful in that situation, because if you didn't police it, and somebody put up a copyrighted piece that they didn't own, a picture or something like that, you could be sued for copyright infringement. So what you have to have in place in your terms of use is, look, we do care about copyright infringement. If you think something is infringing your copyrights, let us know and we take it down. You see. Here's the next thing is, if somehow you're sharing information, let's say you have a website that connects, volunteers with people who need jobs or something like that. Okay, well, you got to have some rules of conduct there. Let's say that the person who hired the volunteer now starts, harassing them or hitting on them or something like that. Well, if they start doing that, then you should say, we're going to kick you off the site. We can block you, things like that. Finally, if you have some sales going on, you'll probably need to set up some kind of credit card transaction portal. Maybe you want to use a third party for that, like Stripe or Plaid or something, PayPal. So you're going to have some terms of use that say essentially our payments are arranged by, Stripe, and we're not responsible for anything that Stripe does. All right, last one, guys. Here we go. Privacy policies. Privacy policies are really important because people use websites and their information is automatically shared with that website there. So here's the point at the bottom is under the California Online Consumer Privacy Act, users generally get to find out not only what information you're collecting on them, but they usually also get the right to ask you to delete that stuff. All right. So, some exceptions to it usually allows you to share aggregate data. So, like all the buyers, or even like all the women buyers, they behave this way on our site, and all the male buyers, they behave that way. And you could actually share that with some kind of marketing agency without violating terms of use, as long as it's not identifiable information. Sometimes government will come along and say, hey, we think some terrorist activity is going on, and so you need to disclose this person's whereabouts or stuff. Yeah, they might do that. And the overall thing I guess we'd say is, look, some people do really care a lot about not getting ads and, not being treated to our business partners' offers and stuff like that. They may say, I don't want any of those emails. Well, set your website policy according to that. If people, let people opt in if they wanted to, if your sense is that people will not generally want to receive this kind of stuff. Right. Phew, I guess that's the main thing. But the last thing I would just say is if you're using one of our templates, always show it to a lawyer before signing it, because it may be, for example, let's say you pull a template off the web. Last one I tried to do earlier today, I was looking for a particular one, and I said, oh, this looks like a good template. Arizona. Okay, well, it's not going to work in California, sorry. So a lawyer would catch this sort of thing. And I would say especially important where there's lots of money involved, like long-term commercial leases or capital transactions or loans or stuff. Definitely have a lawyer look at it beforehand. All right, guys. Well, that was long, but hopefully if anybody hung around, want to hear that, they got what they were looking for. It looks like Deide, I think it is, wants me to send the independent contractor agreement and the NDA of mention agreement. I can do that. Let me just get that there. Sandra, hopefully you're going to send me the chat here, but I could write this down real quick. Wait a minute.
I think she sent it directly to you. I don't see it on the main chat here, Bill.
That's all right. I'll write it in here. So it's Sanchez at uwlf.org, right? Okay, and what you want, the NDA, the IC agreement, and the invention assignment agreement. Yeah, I can send those right along. Sure. Okay. And if anybody else wants some stuff, just email Jocelyn if you want some stuff. Raina. Oh no, Raina, you're with FH. I'm sorry. Just check with Sandra, and I'm sure she can put you in touch with us. So, but Deide, I think she had to leave, so I'll just follow up with her on that. All righty. Well, thank you, everybody. Hope you have a really good weekend, and we'll be up for the workshop next month. I can't remember what it is, but we will be here and we'll give you some good advice and information. Oh, not advice, information going forward. Okay, have a really good weekend, everyone.
All right, thank you, Bill. You too as well.
Okay,
bye,
take care.
everyone.
All right, bye-bye.